Good afternoon. I'm Eula Clark, Mayor of the City of Stuart, calling to order the regular meeting of the Stuart City Commission on June 28th, 2021, 5:30 p.m. in the Commission chambers located at 121 Southwest Flagler Avenue in Stuart, Florida. Welcome to our meeting. Clerk, would you please call the roll?
Mayor Clark,
Yes?
Vice Mayor Matheson,
Here.
Commissioner Bruner,
Here.
Commissioner McDonald,
Here.
Commissioner Meyer.
Here.
Those in the room, please stand for the Pledge of Allegiance. And let us consider the state of our community, of our state, and our nation as we are led in the Pledge of Allegiance by our Vice Mayor, Merritt Matheson.
Thank you, Mayor. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Our first item is comments by our city commissioners. We'll start with Commissioner Bruner.
I have none, thank you.
Commissioner McDonald.
Yeah, a couple of quick things. One is, I want to just wish everybody a happy 4th of July coming up this weekend. I'm looking forward to the fireworks. I actually won't be here for them. I'm going to be celebrating my 24th wedding anniversary with my wife. So,
Happy anniversary.
because we got married on Independence Day. But anyways, I want to just pass it along that everybody have a good, happy, safe 4th of July this coming week. Also, one of the things I just took note of is that when we're and we're going to be discussing some stuff later, and it's a different discussion, but when we vote now, the voting order has not been completely random, and the mayor always votes last, and that was something that had never been that way. And I really would like to see us, if it's up, to the commission, that we go back to a completely random voting order.
I didn't know the difference.
I thought it was random.
I thought it was random, but
It's supposed to be randomized.
But except for the mayor always
hasn't
votes
been.
last, so that's not random.
no.
Well,
I
we
voted
can blame the
first.
clerk that's present for that.
I voted first
So
before.
I don't know if the mayor going last was a decision by the commission previously, but Robert's rules actually has the chairman of the board going last. In November, we adopted the chapter 2, and one of the things we adopted in it was Robert's rules. So it could be, and Mary's not here, so I can't ask her, but I'm assuming that when we adopted Robert's rules as our default procedure, that Mary probably started being the strict letter of Robert's rules and calling the mayor last. But if the board so pleases, and it probably makes sense, I'll give Mary the information and we can begin and go back to the completely random nature of it, or it should at least be completely random. And she can either get a randomizer and have it on her screen, or she can literally put the names in a hat and pull them out however she wants.
Okay, that's all I have.
Thank you, Commissioner McDonald. Commissioner Meyer.
Thank you, Madam Mayor. I would just like to say, I know many of us, our thoughts are with those missing in Surfside after the building collapse, that great tragedy that has garnered international attention. It's just terrible. At the last, one of the last meetings when we talked about housing, there was some discussion around impact fees. And I'm glad that we did not discuss really eliminating impact fees or offering impact fees up as a way to incentivize development. I didn't ask for it to be put on the agenda, but I did read recently a great op-ed by Maggie Hirchala, kind of alerting the public generally, and we've talked about this here in previous meetings about the bill that was signed, capping impact fees in the state. Maggie explained that to the public and described the challenges with new development and how capping impact fees would be detrimental
to say the least. So I thought this might be a good opportunity for us, if it pleases the board, for us to have a discussion item, have staff present to us, when was the last time we looked at impact fees here with our city, and assess whether or not they might need to be updated in light of recent development and projected development.
Sure.
And and if we need to start planning increases because they'll, now they're capped.
So,
Do
just,
you want us to
I don't know
set
if we need a
time?
D&D item on that or not, just for your information. I have asked Mr. Freeman to budget that for another study, because you have to do a study for these impact fees, and you have to do them, they have to be timely. So our last one was 5 years ago, so we'd be due for another one in the next cycle, so the study would occur next year.
Next year.
And I'll also comment, one of the things about the impact fees that is significant is that it's not just to collect the money and you can't just stripe roads or whatever. You actually have to create new capacity. And a lot of times when you look at a city like the city of Stuart, to collect road impact fees, you have to then go around and say, okay, where are we going to build these new roads? And sometimes building new roads generates construction itself, just because the new roads have new locations for the people to be on. The same thing goes with libraries, same thing goes with parks, same thing goes with all of the stuff. So doing the study doesn't necessarily mean an increase in impact fees. Sometimes it could actually mean a decrease if you don't have roads programmed.
That's a great point, but I would also like to
So we have to do it statutorily, it's legal.
Yeah.
Yeah.
But I'd also like to suggest that there is some movement in other communities, some very close to us, pushing towards mobility fees in lieu of transportation impact fees, which have a broader,
And we have them.
so that, we can get around things.
Right.
So
I mean, but we
our
have adopted
transportation
mobility
fee
fees.
is a multimodal fee.
Right.
Yeah, so ours can be for multi-use paths and bike lanes.
If I may, we did, I remember when we did that study 5, 6 years ago, and some of the things we found was that we were over capacity on parks, and so there was an adjustment, I think, downward on parks. We changed to mobility fees, to transportation for mobility, so we'd have more latitude for the use of those. So, but it is definitely a good thing to do every so often, because the environment changes. So,
Right.
So,
Okay, thanks. That's all,
Mr.
Madam Mayor.
Vice Mayor? Thank you, Commissioner Meyer.
Being that it's the meeting right before the 4th of July, I just want to stress, as Commissioner McDonald, that everyone have a happy 4th of July, and especially all those throughout the city. Remember peace and civility when you're celebrating, especially those in East Stewart where we've had overexcitement in the past. Remember your friends and neighbors are there, and fireworks can be damaging. Remember to respect law enforcement. And while you're celebrating, please obey the rules. We have a couple big meetings regarding Lake Okeechobee and its management the next 2 days. Currently, the lake is at 12.66 feet. Tomorrow, the South Florida Water Management District will be holding a workshop to discuss LOSUM and potentially advocating for one of the 6 plans that LOSUM is about. That's at 10 o'clock tomorrow. You can attend in person, I believe, or virtually. It's on their website, is the link. The next day, the 30th, the the Army Corps of Engineers will be holding a workshop discussing those plans, although they won't be picking an official plan, and that will be a virtual meeting, and you can attend through WebEx on them. If you haven't been in tune to the process, I would recommend, if you have time, to tune in for the South Florida Water Management District workshop. They work, in sync with the Corps, and their decision will throw a lot of weight on probably what the Corps decides. The presenters are Lieutenant Jennifer Reynolds, who was the former commander of the Jacksonville District and now works for the South Florida Water Management District, and Tim Geisen of the Army Corps of Engineers, their project lead for LOSUM. I've looked over the slides. It's very informative, especially if you haven't been involved in the whole process, to get you caught up to speed. And the decision that the district may or may not make tomorrow, they don't have to back a plan, will have significant impact on how LOSUM is shaped. And other than that, again, everyone have a happy 4th of July. I know I received an email, I think we all did, from our city manager about a walk for peace in East Stewart. And hopefully either the mayor or the city manager can tell us a little more about that. I'll be out of town, but I'd encourage those to participate if they're able to.
Thank you, Vice Mayor. On June 24th, I had a meeting at the 10th Street Rec Center because residents had asked about trying to make sure that the young people, especially in the East Stewart area, will have an opportunity to enjoy fireworks in their own special way. And there was also some concern about having acts that could endanger the traveling public or property in the area. And that has led to some of the folks in that community and surrounding areas to come together. And like Commissioner Vice Mayor just said, they're hoping to have a little walk around the community tomorrow, and also to find some ways to encourage everyone to come out to our fireworks on July 4th. There are flyers outside, and also to be safe in whatever community or home you are, to enjoy your July 4th holidays. So we appreciate that. I just wanted to thank Mr. Leggett and his staff and city manager. I had sent out some requests on Moore Cemetery, and they've responded promptly. And there's some other work that they're doing on the Moore Cemetery, and I'm looking forward to that. I'm looking forward to also getting back with some residents in the community who are concerned about Moore Cemetery, so there'll be more for that. I have had people ask me what is going on with the city in terms of when we have lawsuits against the city or the city is involved in a lawsuit. Do we get regular reports, or how much money are we spending on lawsuits? And I was just gonna ask if there's a way that we can either develop a protocol or just call on Mr. Mortel to maybe give us twice a year or once a quarter, just an idea of how many lawsuits we have and what type they are, even without even disclosing the names or anything, just to let us know if we have had several property lawsuits with injury at, our parks or something like that, or if there's something going on. So I don't know what the feeling of the board is, so that we can just try to get a handle. And of course, I'd like to also know how many of our lawsuits we're spending outside staff or anything on. Of course, we have to approve those, but it's just the idea of making sure that we're keeping tabs and checking on things. So I don't know what the feeling of the board is, or the commissioners, if you'd like to have a little report.
Well, so if we have lawsuits from, like a liability lawsuit, somebody falls and hurts themselves, is that usually covered by our insurance carrier?
So
Trico.
we have, Trico has a list of files that they're representing, and I can meet with anybody, off the dais anytime they want to talk about them. When I meet with the Trico representative, which is about once a month, she has the list and we go over it, but she doesn't leave a copy with us, and they consider it very confidential, and they don't like to leave it in any public settings, and they don't, because it's got work product on it and other stuff. So it's pretty small right now. As far as outside expenses, there is zero litigation, with the exception of the PFOA case and the opioid case, but that we're expending funds on but that's contingency fee only, so we're not actually spending money. And then any cases that I'm defending for us in-house, really the only in-house case that's pending right now is I have, 2 or 3 forfeiture cases that come and go very quickly with the police department. And then it's the North Point case that, I'm not helping them pursue their claims in any way. So if I don't file anything and we don't talk about it publicly, they don't do anything. We almost had it dismissed for lack of prosecution once before, and then there was an article in the newspaper and they filed some paperwork again. So sometimes bringing that stuff up does remind people to do stuff, but I'm happy to meet with you guys quarterly. I can bring it once a month for all I care. It's just, I don't know how much information you want for it.
Well, if we meet with you individually, I mean, some of this stuff, if the case is still
If the city had to
pending-
take action, like the North Point case, I would have to get your authority to do it, so I'd have a shade meeting. But I can only have a shade meeting for a case that's in active litigation. I can't have a shade meeting for something where someone sent us a letter or that we think might go into litigation. That has to be a public. And quite frankly, most of the time I try to make them public anyway because, with the exception of a settlement negotiation or something like that, we take the action on the dais.
All right. So everybody's satisfied with that way of dealing with things then?
But I'm happy to bring, like at the next meeting, I can bring back some numbers for you, just to give them to you.
Okay, just so we have an idea. Okay, and of course, I wish everybody a happy Fourth. The status on Shepherd's Park, I don't know if when city manager does his report, tell us about when Shepherd's Park would be finished with all those changes. And Commissioner Meyer brought up the housing and zoning issues. I know that when we had the inclusionary zoning discussion, the discussion also led to actual land use and zoning in the East Stewart area. And I saw that there was some interest, and I'm wondering if staff is planning to meet with those residents and try to bring back and bring an understanding of the PUD zoning, the special district land use, which is called East Stewart PUD. So I just wanted to bring that up and to let Mr. Freeman know that hopefully give us an idea of when something like that may get out to the public again for them to get a chance to discuss that, since it was discussed and brought up by actual residents at the housing meeting. I have in my hand here a DEO letter with regard to the plan amendments that recently went up, and of course, that includes Costco. And so, of course, if any member of the public wants to hear what the DEO has sent back to us, this is it. And I think that Costco is scheduled to come back on July 26th, is that correct?
26th, the tentative date?
Yes.
Yes, I think so, okay. All right, so there's that response. Then the Stewart Feed Store is going to be having 107 years, 100 and something years. They're going to be having an event over there. And I'm going to be participating and probably prepare a proclamation for them. But I just wanted to congratulate them now, and we'll be doing it more formally with regard to the use and the activity for the Stewart Feed Store and how they've been instrumental in keeping our downtown vibrant in their own way. Also, I went to a graduation from the Business Development Board. We just had our first budget workshop earlier on today, and sometimes in the past we've asked, I know that Commissioner McDonald has been true to this on his prior time on the board, what happens with the money that we give to the Business Development Board, and how are they assisting businesses in the community? Well, I went to a graduation where they had like about a 6-week course with persons who are going to be starting their business, and they also have a program coming up on business hustle and different ways to do things. And I just want to applaud the Business Development Board, and they've also sent us a letter telling us of their activities and what's going on. So I just wanted to they have some concerns, of course, about things happening in the community, but I just wanted to let folks know that the Business Development Board is basically working to meet their product requirements for the funds that we're giving them, so I wanted to at least applaud them for that. Other than that, I don't think I have anything else. And again, a happy 4th of July to everyone. City Manager?
Yes, ma'am. As far as the Shepherd's Park, it will be finished in late August. We'll be looking at either ribbon cutting in late August or early September, but that project should be completed in August with the larger trees going in sometime in mid-August. The East Stewart zoning that you brought up, we were contacted by the Regional Planning Council about having them be the liaison and conduct that project. So I know Kev has been speaking with them and trying to see what that looks like and what that cost factor would be for having them step in and work with the city and the East Stewart community to bring that to a resolution.
Great.
By way of just information to the commission, I was contacted by New Urban, who is developing the Avonlea 16 property, and there was an issue there because their original drainage was not approved in the Avonlea project as a whole when that was done during the master planning. It stayed with the Green River Parkway drainage system, and so there is a need for them to move their stormwater drainage, and they're willing to and want to do a piece of that on the city's property. So it'll wrap around the front of their property and then connect into the city's property and then out into the Haney shed. And so that I'm just writing a authorization to Martin County to let them know that we are in agreement with that. And that's all I have.
Thank you. We have an agenda approval.
So moved.
Second.
Okay, there's did you get that, Jordan? Commissioner McDonald and then Commissioner Meyer. All in favor?
Aye.
Aye.
Aye, thank you. All right, we have comments from the public, 3 minutes. Let me see if there's any on any agenda items. Okay, if you do have it on an agenda item and you want it after the agenda item is discussed, you can decline when I call your name, but I'll be going through these. Mr. Walter Lloyd.
Walter Lloyd, do you need my address since it's on there?
Yes, sir, yes, we have it on here.
Okay, yes. Thank you for hearing us. In general, you may have seen me come in with the previous meeting in the Costco issue. But I learned a lot in that process. So in sitting through all of that, I think some of the things that I did learn were the processes of annexation and the information that flows and the representation that we have or don't have. I wanted to point out that in those processes, that as a county member, when we are coming into annexation with zoning understood or not, putting out a PUD that will make that plan, those things, I don't see how they are realized by the county. When that annexation takes place, you folks are making decisions for a whole lot of people where your annexation protrudes into our environment. And I would like to understand or have you plan for us how we can know better up front what's gonna happen, and then how we can impact it. Because I saw a developer come in with all the expertise, and when we tried to come in just representing our communities, because we weren't experts, our testimony isn't weighted like theirs. So how could we have known that we should have brought in experts without just common sense maybe? And I'm guilty maybe of no common sense in this process, but I would like to think that our impact, what we say, would weigh just as much, and or we should be directed to bring experts that would weigh just as much as these folks. They're coming in from out of town impacting our lives, I think we should have that right. You as representation for us are pretty much acting in impunity, with impunity, because we don't vote for you. We're in the county. We're being impacted by decisions you're making, but we can't make changes if we don't like the kind of decisions you make. So please, when it comes to this decision, these kind of decisions, figure out a way that we can understand better. A blue sign is great, but it doesn't give us much time from the time that blue sign goes up to the time things are steamrolling over us. We need you, we need your representation at the county level, or we need a process where our county representatives have a say in the process. So thanks for hearing me.
Thank you, sir. Corey Pritchett. Amy, sorry.
Never been called Corey.
Amy.
I kind of like it.
Sorry, Amy.
Good evening, everyone. I'm directing this to you because you mentioned Maggie Horchella, and I happen to have read that article as well. And as a fairly newcomer to Martin County, it was of great interest to me. Martin County is supposed to update that every 2 years. And I think I understood from Mr. Mortel that the Stuart, it's every 5 years. I'm wondering why that discrepancy with updating the impact fees. That's number one. And number two, I attended the joint meeting last week, and you perked my ears up with your possible resurrection of sales tax to residents to conserve already conserved property in Martin County. I don't think that burden should be on the residents. I think the burden should be on the builders who come in and try to take our lands that are on wetlands, that are impacting wildlife. I don't think the residents should pay to conserve space that's already conserved. That's just a general comment. And one more thing, I wish everyone a happy July 4th. I'm a real animal advocate. Please take care of your pets. Don't let them out during fireworks. Don't let them suffer. I have pets and they suffer with fireworks. As much as I love them, they don't. So keep your animals inside and safe. And happy 4th of July to everyone. Thank you.
Thank you, Em. Gail Goldie.
Good evening. I just want to say that I was here at the last meeting for the Costco, and I would like to just hit upon the wetlands issue for that property. At the time of the European settlement, it was estimated that over 200 million acres of wetlands existed in the United States. In 1975, wetlands were estimated to be 99 million acres. So you can see the huge decrease. And that was in 1975. So you can imagine how many more have been destroyed. It's very, very important. Amy mentioned the wildlife and a lot of the native vegetation that's there that should be protected. I understand there's mitigation. I know that they're targeted to be moved. I, for one, just cannot understand how you can just pick up some piece of wetland and go stick it somewhere out west on whatever piece of property is designated to take these wetlands. This is very, very important. We're seeing the demise of a lot of our treasured properties out here where there are wetlands and there are animals and all kinds of vegetation that I don't want to see destroyed. And Michael, I see that you have quite a grin on your face. So I'm hoping that you're in quite agreement with this. You know, this is not something that the residents take lightly. We're very, very concerned about what's going on. This apartment complex, along with Costco, is not the only thing that's on the drawing board that's coming up for more approvals in the future. We need to slow this destruction and this increase in all of this going on. Thank you very much.
Thank you, ma'am. Thank you. Drew Simeone.
Stuart is changing, and I'm afraid that the unique qualities that drew us here are slowly eroding. For the first time this year, traffic did not noticeably reduce when the snowbirds went home. And as I drive down Federal and Canner highways, nearly every piece of undeveloped land is for sale, sale pending, or sold. Sadly, our market is no longer locally driven. Out-of-state developers have found Stuart, and they don't necessarily have our best interest at heart. The worst evidence of this is the 398 multifamily apartments, retail, restaurant complex proposed for development between Canner and Willoughby, near the high school, which last but not least includes 18 gas pumps and the ultimate big box stores, Costco. While big box stores are good on paper, in reality they generate far less tax revenue than anticipated, and they create far more traffic and headaches for the local community. With such a glut of vacant space all around us, every plaza, I believe it's in Stuart's best interest for this commission to consider a temporary moratorium on all new development. In lieu of new development, Martin County should prioritize the filling of existing spaces, much of which was created by the COVID crisis, utilizing economic restructuring and creative adaptive reuse techniques. To this end, instead of building a new Costco, Costco should be encouraged and incentivized to renovate at the empty Sears space at the Treasure Coast Mall. Such a move would keep Costco in Martin County, but in an appropriate, non-detrimental location. It would restore a much-needed anchor to the mall, generating foot traffic, revitalization, and momentum. There's ample parking, traffic lights and turning lanes are already in place, and roads are equipped to handle heavy truck traffic, as well as handle multiple daily deliveries, unlike a location so close to where kids walk to school. You know as well as I do, all development isn't good development, and the future of Stuart is in your hands. I truly hope you will consider enacting a temporary moratorium on new development and instead prioritize the filling and renovation of existing commercial spaces until such time Martin County is restored to its pre-COVID state. I also hope that first and foremost, you will value the quality of life of existing residents over the plans and schemes of out-of-town developers. Thank you for your time and consideration.
Thank you, ma'am. Ms. Linda K. Richards.
Good evening. So here we are. It's back from the state, and it's back down to the 5 of you deciding what's going to happen to this 50 acres of land. I'm not an expert, and we know that, but I know this land, so I want to talk to you about it from a first-hand perspective. I've been all over that land, by foot, on dirt bikes, on golf carts, on swamp buggies, on 4x4s, on foot horseback. They're low and they're wet. The lands manage a lot of water during our rainy season. They're home to gopher tortoises, little blue herons, great egrets, red-shouldered hawks, wood ducks, and countless other wildlife. But wait, we have an environmental study, you say, by an expert. An environmental consultant hired by the applicant, paid for by the applicant, EW Consultants. I'd like to remind you and inform you that who might not know, but EW Consultants did the environmental report for Bridgeview, and it was found out that they completely disregarded protected and threatened wildlife. But the project had already been approved, so it was quietly swept under the rug. And as you know from my letter 2 weeks ago, we have found and documented threatened and protected plant species in the upland scrubs. We also observed wading birds like the great egret and little blue heron foraging in the wetlands. But you read this report and it says things like disturbed wetlands and invasive non-native vegetation. Absolutely nothing worth saving. And this report makes you feel okay to give it an approval. It makes you feel okay that they come and clear cut every last tree on the property. It makes you feel less impacted when 8 distinct wetlands are destroyed. It makes you feel okay with displacing hundreds of gopher tortoises, taking away the foraging grounds of the little blue heron and other wading birds, the trees where the red-shouldered hawks nest, and the meadows where they pick up a field mouse for dinner. But a report by an expert makes you feel okay because it's disturbed and invasive. This piece of land is special, and it's the last of its kind in Stuart. And I will continue to reiterate, this land was designated low-density residential, and to turn around and improve something so drastically, so much drastically more is downright unethical. It's not just the Costco or just the high-density apartment complex, it's the entire PUD that bastardizes the intent of the PUD. And lastly, again, I'm no expert, but if you believe clear-cutting 50 acres, destroying all the wetlands, and covering 75% of it with concrete will result in better stormwater management, then we have truly lost sight of what Mother Nature intended. There is so much more value in this land to the city than what this development is offering. I know there's a strong drive to have Costco in Stuart, but to allow this developer from New Jersey to take some of the last undeveloped lands of Stuart and produce such a monstrosity of a development just for the sake of having a Costco in our town is unethical and inexcusable. And it will be your legacy that you will have to live with. I know a fact that I will know that I have done everything in my possibility to keep Stuart a quaint seaside town. And it comes down to the 5 of you to make a decision that's going to outlive all of us. Thank you.
Thank you. Ms. Sarah Menker?
Hi there. Thank you for having me. This evening,
Speak directly into the mic or take it.
This evening, I was going to delve into debunking the whole Costco being the messiah of conscientious consumerism and that they're ethical employers because they have spent $53.25 million on employment-related offenses. I don't know if any of you have researched that, but they have repeated offensive and local offenses, actually. They recently spent $750,000 to a woman who worked 24 years for them. Her ending pay was $20 an hour. What I really want to get into is the plan, because I feel like this was not looked over by the people that needed to look over it. The architecture firm that you're using, Form Architecture, I'm familiar with. I've been in their buildings before in Tallahassee. There are 3 pages in the Leon County court records of lawsuits with this one architecture, this one complex that they built. They have been sued multiple times for negligence and not complying with codes. And in light of these recent events, I think this is of the utmost importance to be acknowledging. I myself have been homeless twice because of illegal construction. And I went over to this one complex because my friend needed me to remove their stuff from their apartment because it was raining inside. They built it, they moved all the students in before they were done constructing, and the alarm system kept going off with its sprinklers. The state of Florida and the Tallahassee Police Department had over 17 false alarms where they went there and had to use their resources to deal with this. And they actually have brought Form Tallahassee as a defendant in multiple circumstances for this negligence. So I really feel like you have rushed this. You're not looking at the full big picture. It's the environment, it's the citizens who already exist here, but think about the new people who are coming in. This is upscale apartments that they charge for, but they deserve sound housing. And if you're gonna put in this much housing, it needs to be sound and habitable. That's all I have to say. I've done hours and hours of research on this, and I hope that you all take more into consideration because I don't feel like that's happened. Thank you.
Thank you so much. Karen Hall?
Good evening. Karen Hall, 1701 Southwest Palm City Road. Thank you for your service. I wasn't going to speak tonight. I was just going to be a spectator. However, my friend, our city attorney, said something and it's not true, so I have to correct that. And also make a point of the administration. Where is the oversight? Okay, because I've been doing this for over 10 years. And when you have no oversight over the administration, then you have things like this happen. here's the deal. You should have a special committee meeting because you do have an open case 16484. If you go on the docket, it says it's open. My friend Mike wants to pretend it's not, and I don't blame him. It is open. There needs to be a hearing set. There's all kinds of evidence there that shows that the deputy clerk said set your motion for hearing. And Mr. Mortel, he doesn't want to do it. He doesn't want you guys to even know the case is open. Now that infuriates me. We are paying you to be honest. Now you have an open case, have a meeting, and settle this. I'm tired of it. Corruption, white-collar crime, not in my town.
Thank you. Is there anyone who needs to speak for 3 minutes maximum who has not produced a card and who would like to speak on open to the public? Is there a green card over there? Yes, Ms. Brinkley, come forward.
Good evening. I really don't have, I overheard something and I came in late, but I heard, City Manager, you were speaking on the project in East Stewart, the housing project, and you said that someone would be working towards, I'm trying to remember your exact wording now. I wrote it down, but I left my paper in the back. But is there a committee that's going to be working on that development project? Or,
Would you like me to
Is
answer?
it the land use for the Church of Goshen Regional Planning
Yes,
Council?
yes.
that's
So-
it?
Yeah, so at one of the previous meetings of the housing affordability meeting, the mayor talked about some zoning stuff in East Stewart. And so the Treasure Coast Regional Planning Council has reached out to us, and we've been talking with them about them becoming involved and being the catalyst between the community and the city to try to move those items forward. So they would be the ones, if it turns out that we go into contract with them, they would be the ones who would come to the community and talk to them about the housing. And they're the ones who did the previous charrette over there many years ago.
Okay, so they will be like the head, if I'm understanding it right, they would be the head of that
Facilitator.
organization.
So,
And
facilitator.
sort of like taking control and talking with the citizens to decide.
Yes.
What's going on. I just needed to understand that, because like I said, I came in on the tail end of it, and I just caught, when you say East Stewart, it'd be like my ears perk up, because I want to know what's going on in my hood.
Thank you, ma'am. Any other comments at this point? Thank you. Let's move on to the consent calendar.
Move for approval.
Second.
There's a motion and a second for approval of the consent calendar. All in favor?
Aye.
There's money.
We need to be a roll call.
There's money
There's money there, okay. Sorry, there are items.
in public comment.
Okay, so, let's have,
Any public comment?
yeah, I want to get some public comment. Yeah, because, okay. So, any public comments on items 1, 2, 3, 4, and 5, which are listed in the consent calendar? If you have concerns, the agenda is available outside. You can look at those items. Clerk?
Commissioner Bruner,
Yes.
Commissioner McDonald,
Yes?
Commissioner Meyer,
Yes.
Vice Mayor Matheson,
Yes.
Mayor Clark.
Yes, thank you. That's the end of the consent calendar. We're at commission action, item number 6.
Madam Mayor, I'll move to appoint Commissioner Meyer as our delegate, since he's our Regional League of Cities appointee.
I'll second it.
Okay, thank you.
You're going to the, I'm assuming you're going to the conference.
Yeah, I'm on a policy committee, so I'm at all of the pre-meetings and the conference and the follow-up conference.
Thank you.
So, yes,
There's
thank
a
you.
motion by Commissioner McDonald, second by Commissioner Bruner, to appoint Commissioner Meyer to attend as a delegate to the Florida League of Cities. Are there any public comments on this matter? Clerk, would you please call the roll?
Commissioner McDonald?
Yes?
Commissioner Bruner?
Yes.
Commissioner Meyer?
Yes.
Vice Mayor Matheson?
Yes.
Mayor Clark?
Yes, thank you.
Thank you.
Thank you. Representative Swell.
Thank you for representing.
Item number 7 is urging the United States Department of the Interior to restore the endangered status for the West Indian manatee, resolution number 65, 2021. City Attorney.
This will be Resolution 65, 2021, a resolution of the City Commission of the City of Stuart, Florida, urging the United States Department of the Interior and the Fish and Wildlife Service to restore the endangered protection status of the West Indian manatee under the Endangered Species Act, further requesting a rule revision to the critical habitat for the Florida manatee to include the St. Lucie River and estuary, providing for an effective date and for other purposes.
Thank you, sir. Do we have any discussion from staff or any, before we have any members of the public?
I'd like to thank Mr. Hogarth for working with me on drafting this resolution. You know, in half a year, 10% loss of the population is, you know, it's just very significant when you talk about the species that reproduces at the speed that the manatee does. And, you know, we can't stress enough how important it would be to have the federal government recognize the St. Lucie River as part of their critical habitat, which I believe it is.
Yes, and Commissioner, Vice Mayor, you know, we've had boating accidents and we've had incidents where manatees have been scarred and hurt, but this is, I call it a climate change, I call it an environmental change in our lagoon area, and this is really something that we need to get the proper funding and investigation to help our wildlife. So I do agree with that. Any other comments from our commissioners? Any, go on.
Any comments, or?
Why don't you make the motion?
I'll make a motion to approve Resolution 65-2021.
I'll second.
There's been a motion and a second. Any comments from the public?
Madam Mayor, I'll just say thanks to Vice Mayor Matheson for taking the charge on this, and it feels like we're kind of at the tip of the spear again. I know, you know, the River Kids had that event, but ever since you brought it up after that, I've just been seeing it everywhere in the news, and so it's great. It's
Well, I
great
know-
that we're taking a position.
You know, this isn't how stuff gets listed on the endangered species list or relisted. But a municipality, you know, supporting it or being on the tip of the spear and causing the alarm, asking for further studies, you know, certainly helps. And that's the intent of this resolution, so thank you for the support.
No other comments and no comments from the public? Clerk?
Commissioner Bruner?
Yes.
Vice Mayor Matheson?
Yes.
Commissioner McDonald?
Yes.
Commissioner Meyer?
Yes.
Mayor Clark?
Yes.
There's that randomized list.
There's no ordinance for second reading set tonight, but we have some matters for first reading, quasi judicial matters, and actually dealing with quasi judicial matters. So amending that, the proceedings, Mr. Mortel, could you please read the ordinance title and then further discuss this matter unless growth management is going to be the one? Thank you.
No, I'm happy to. This is ordinance number 2467-2021, which is an ordinance of the City of Stuart amending Article 11, Section 11.03.00, titled Quasi-Judicial Proceedings, providing for severability clause, the conflicts clause, and providing for an effective date and for other purposes. Essentially, our code had language in it as it relates to a quasi-judicial proceeding. all 5 of the commissioners at a meeting following the Canner Highway PUD had talked about making revisions to that proceeding. And we present to you today the
Mike, could you speak in your microphone a little better?
the amended, proposed amended order. For whatever reason, just so you know, as I'm looking at it on the agenda, I actually had it in red line and marked up, and it didn't transfer into the agenda. I don't know if yours all did or not.
No, I had to pull up Unicode to see what was current.
And I don't know why that's the case, because I uploaded it as, like, if I pull it up in Word on my desk, it's like, you know, red ink and lines through the stuff and everything.
There's a special way you got to do that. I'll
There's
show you.
yeah.
Okay, because it didn't transfer right.
There's a little L for
So as I'm
something.
looking at it, I mean, there are some that are underlined and some that's added, but it's not all there. I can, for the second reading, I'll be sure and have the redlined version adopted in it.
Well, Madam Mayor, I'll make a motion to approve. I have a couple discussion points, but
Would second, I had some edits and perhaps, you know, it's rearranging, it doesn't change the substance.
Okay.
I'll mention those edits.
Okay, so there's a motion and second, and I have some comments. Usually I wait until last because everybody makes all the good comments, but I will let you, I'll let you go. Since you want- No, actually, I mean, the idea of including all the items that are on this sheet, and again, because I didn't see the detailed markup with the red line in, but one of the things that I wanted to discuss with our board tonight is that when we had the Costco hearing, which lasted so long, was because even though I think maybe people's views might be different, the intervener as well as the presenter, I think they got ample time and more than ample time, and that took up a lot of things. And I think I'd like to see a format, and I'd asked city managers to look at what West Palm Beach did and what the Board of County Commissioners did, because I think the Board of County Commissioners, I think I've read this before, but I haven't read it recently, that they actually give like a 45-minute time frame, I think both at the LPA and at the commission meeting, for the presenter, the plaintiff, as well as any intervener, to present their case and then have their rebuttal, and then that would bring the public in at an earlier stage. I think we went on exhaustively because we had the discussion from commissioners in between some of the presentations. And I know that sometimes when you have a developer who comes in, who may have a traffic engineer, who may have severe environmental issues that need to be presented by a specialist environmental person, or water resources issues. And so all of those specialties may be asked on to do their own presentation, but I still think that they can get it as lucid and as brief as possible in a certain time frame, even if it's just an hour each for them to get things out. They'll have time to rebut, and then they'll have time to come back. But I think it needs to be a reasonable time when the public can be expected that this is going to be presented, and then they'll have time and not wait for 3 or 4 hours later. So that's the only thing that I didn't see a time frame in here, but I know that other people are going to have comments. But I think that the new format, it does give a great deal of guidance, and specifically including what we actually do in there is also important, because I think one of our speakers tonight mentioned something, must have Mr. Lloyd mentioned something about making sure that people know how to approach us and what to do and how to prepare. And this is one of those things that will give them some guidelines, because they'll know exactly what we're asking for. Of course, we have some more details in here about what we need to do, and we declare when we have spoken to people. But I'm going to leave it to all the folks who like to go into very detail, like Commissioner Matheson. So let's let Commissioner Meyer go first.
If I can quickly comment on the time thing, we kind of reviewed that when we were putting this together, and let me give an example. If somebody were to come forward right now with a PUD related to the property that's on US 1 that used to be the old SPS property down on South US 1, it has no trees, it has no wetlands, it's on the adjacent side of US 1, it's adjacent to an industrial park, it's not on the water, And to compare that to, say, the Costco site that has trees and wetlands and stormwater, and to say that the applicant for a PUD related to the SPS site should have the exact same amount of time to present their
I hear
case
you.
as the person related to the Cantor Highway, it just would be impossible and unfair to treat each thing as the same concept. And so what we thought is if the board felt the need to apply a timeline on a case-by-case basis, they're free to do that at the meetings as they arise. In addition, I was on the LPA in 1994, so I've been coming to these meetings since the early 90s, and I can think of one meeting that lasted past midnight since 1994. So we didn't think that the Costco meeting was a recurring problem. It just simply, a lot of people were involved, there was a lot of issues, and it took a long time. And our perspective on that was, if it's going to take a long time, let's just set it aside. And rather than giving timeframes, I'd rather tell people at the beginning of the meeting, look, we project this meeting to last 7 hours. We're going to cut it off tonight at 10 o'clock, and we're going to pick it back up at the next available time, and we may not get to whatever we get to, or something to that nature, rather than restricting someone from presenting evidence that the board might think is inherently important.
That's fine, I just started the ball. Mr. Meyer?
Thank you, Madam Mayor. I tend to agree. I think if we were to set a time limit, I think that could be arbitrary. I think there are cases like the Cantor CPUD that I want us to be able to have plenty of time for both a petitioner and an intervener to make a full case and do cross-examination and ask each other questions. I think, from my perspective, what caused the thing to run on as long as it did was we got involved. I know I was guilty of that and asked many questions, which should have been reserved for deliberation. So I see this being that the deliberation is much more clearly defined, and that public comment comes before deliberation. So I think setting a time limit is not wise. I think it might actually harm the process of us getting of a petitioner and an intervener to be able to make their full case and for us to understand best, and then have the public make comment before we get to start asking questions. My main, not concern, but question is, we very clearly define intervener in this proposed edit. And I know we had discussed before, just kind of as a matter of policy or tradition, that perhaps in the past, some folks have filed as an intervener, and while they maybe technically didn't legally meet the standards for being an intervener, we still allowed them to intervene. And I wonder if this is going to, this to me more clearly spells out, you may not file as an intervener unless you can prove standing.
Well, and you're absolutely right, and what happened is I went to the case law and I went to the other matters. The reality of it is in the event of a challenge, whoever that intervener is would be required for their testimony to be relevant in the hearing to provide the challenge. What concerned me was when we received an objection from the petitioner that said they didn't meet the legal standard, and we said, okay, and moved on, I started thinking to myself, well, what would happen if this did go up on appeal? Would all of the testimony that was presented by the intervener be stricken, or would it be allowed, or what was it? And so then I started thinking to myself, well, how do I resolve that? And honestly, I threw it in there. You guys can keep it more open if you're so inclined. The other side to an intervener is the intention is that anybody could appeal anyway, whether you were an intervener or not. It's really a matter of course. That definition came from like the case law on it. And the other thing that I did add was that I feel like the commission should rule on that before we get started. And even if they denied and we're moving forward, that's fine with me, but we shouldn't just leave it kind of not responded to. And then it would be the discretion of the petitioner to say, I want to go up on appeal and resolve this before the hearing goes forward, or not. And, they could delay the hearing if they wanted.
Yeah, I'd like to hear what my colleagues think about that. I tend to I think to be careful, we probably should follow the letter of the law and maybe have more strict standards for what an actual intervener is, how they are defined, and then maybe limit other comment to public comment. But, I mean, I also don't want to limit public participation in a way that seems like we're changing the rules.
Yeah, Vice Mayor?
Well, regarding the current topic of an intervener, I feel like I'm always going to have a significant amount of flexibility on that intervener definition, as long as they live in Stuart or Martin County. They're impacted. I'd have to do a bit more research and sit down and discuss the case law. But that's the way I typically stand. You know, if a resident feels that they're impacted enough to go through the steps that we have, I'd want to hear their case. Regarding time limits, I went back and forth on that, and you know, I want to apologize for the questions I may have asked prior to deliberation during the Costco hearing. But my thought with time limits is if we give, you know, every PUD a standard set time limit of an hour or half an hour or 2 hours, both sides are going to stress to use that amount of time, even if it only takes 15 minutes to do the presentation, because the you know, it's short and succinct. You know, if they have an hour to do the presentation, they'll be stretching it out. Or in the case of Costco, I feel like, you know, it's better for the public to have both sides. I think we could do better if we are predicting on, you know, a time-consuming discussion. We have the meeting earlier in the day, which I would suggest when Costco does come for second reading and everyone has a second chance to weigh their input, that we consider, you know, starting that meeting significantly earlier. I mean, I can look back in the past few years. It was Costco, it was Sailfish Ball Fields, it was the discussion over the Pelican. We all knew those were going to be long meetings. But I'm at this point, I kind of agree with the way it is really written. I do have some edits I'll go over, but you know, I don't feel comfortable. I feel like giving each party room to have the flexibility to make their presentations no matter how long it takes. We just need some organization and perhaps holding the meeting a little earlier. I agree with the essence of what was written, where, you know, the deliberation happens after public comment. Each side gets to present their case, then you hear public comment, and then you hear a summary. Some of the edits, if we go to the ordinance, section 11.03.07 on page 4 of the ordinance, number 11, which refers to kind of the mayor's cheat sheet, which, you know, anyone who served as mayor can reference up there, is kind of the current way, where it says in quotes, "Does any member of the public wish to make a comment on the pending motion?" And at that point in the quasi-judicial hearing, there should, the new edits, there will not have been a pending motion. So I would suggest we edit number 11 to, "Does any member of the public wish to make a comment?" Period. Number 12 would read then, "The mayor offers each party the opportunity for a brief summation." And I would have at that point, in parentheses, "No new evidence is permitted." Then the new number 13, "The mayor requests the commission to deliberate and come up with a motion." One more edit would be on page 6 of the ordinance. that items B and C need to be flipped. That just describes, again, well, the way it is now, the petitioners are granted the opportunity to provide a summary of their case after deliberation and a motion has been made. And that's not logical. First, you would have each present their case, public comment, then the intervener and the petitioner could summarize briefly. That way they could, address some comments made in public comment, but they're not presenting new evidence. Then the commission, we would deliberate and make a motion.
I don't know, I'm happy to change that, but B and C weren't an actual order of the proceeding. It's more just statutory language. If you read C, it says, each party shall be entitled to a brief summation after the public comment period in order to address the issues raised. So that would take place before the motion. But that's fine, I'll flip them, it doesn't matter.
Yeah, I think if anyone's reading it, they're going to read it. It's similar in just adjusting our cheat sheet so a year from now, say,
I agree with the comments on the sheet have to be changed, but on this page 6, it just happened to be where it fell in the ordinance. I just added C because B was already in existence, but I'll flip it.
But, those are all my comments. I'm comfortable at this point with the way the intervener is discussed, and I know myself I would be as flexible as possible to allow.
So, and let me reiterate that before you guys make that decision too. So let's fast forward, not the current case because it's been addressed already, but new case 6 months from now, applicant walks in, somebody intervenes, our code says anybody can intervene at any time. And then the applicant walks in and says, here's Florida case law. Florida case law says that an applicant has to be held to this standard that I've included in the code here. And then you guys, as that judicial board, are going to have to rule on that day whether they have standing to intervene based upon Florida law. However, the intervener is going to think that it's based upon what language is in our code, and the applicant's not going to care what language is in our code. They're going to say it's what the state of Florida law says. So my concern was that it's leading the intervener on a little bit, and then they could get really surprised at the hearing to find out that although the city is pretty open-minded to it, if somebody really objects, there really is a standard that has to be followed.
I mean, I read this to say that this isn't before we even have the hearing, that
At the
Mike,
beginning, before
Mike
the
will
hearing
have
starts.
already ruled administratively on whether or not somebody could file as an intervener and present them.
No, what'll happen is someone would apply, no matter who applies, I don't have the authority to rule. It's a quasi-judicial's decision. So if somebody applies for intervener, we'll accept the application fee, and they'll move forward. And they'll get here on the day of the first reading, and then the applicant will object to them being an intervener, and the city commission will have to rule. But it's supposed to be based upon what the state law is, so then the question becomes, if our code says, hey, anybody can intervene, but somebody's really adamant about it and says, I'm sorry, that's not the burden. The burden is you have to show more than just being a neighbor. You have to show X, Y, or Z. I don't want the intervener to be surprised and say that. Now, as staff, if we get an application, we don't have the authority to say no. It has to process.
But can't you explain that in the intervener application process, that this is what's going to happen, and the applicant might?
I found out that Brian DiVentura was an intervener in this particular case 2 weeks after he had paid the fee and submitted the application to the clerk. So I wasn't even present. I don't know that he sent it by email and sent a check in.
All right, well, that's something we need to.
Yeah, I mean, so just so we're clear, right, there's more going on there.
Well,
So,
right.
right.
Well, that's
So
something
maybe
that
we add
can-
something here. If you guys have other ideas, that's great.
Well, one, if someone does apply to be an intervener, we need communication fully at the staff level. And two, if you foresee that there's an objection by the petitioner, correct me if I'm wrong, but still the burden of proof is on the intervener for
Right,
them
and-
to prove that
And in the
they
Costco case,
have
Bob Raines
standing.
objected at the beginning of the hearing, and you guys didn't rule on it. You moved on.
Well, we'll look for
Right, well, and I
better
said,
counsel from
that's
you.
what I said at the hearing, well, we're pretty liberal about it.
That was us allowing it.
Okay, but what was our basis for allowing it? Did we follow the state law? Did we have a finding that they did have higher standing than just being a neighbor? Because we didn't.
We'll have to spell it out better next time.
Reasons, yes.
I mean, there was no evidence presented at all. And that's why I added this, just because I don't know that anybody, what happens is, the applicant, because time is money to them, doesn't want to delay to fight over that issue. But as it becomes easier and people are being interveners more, for whatever reason it might be, whether they're more engaged or whether it's simply because they're more aware of it, the applicants feel like it creates a, the one before that where there was an intervener, there was a little animosity between them and there was pushback. One of these hearings, the applicant's gonna say, nope, we're gonna wait, you rule, and we're gonna continue it today, and we're gonna get a ruling on this. And I just wanna make sure that our record is clear on it. And now, maybe they don't, and when they don't and they waive it, we can move on and we're great. But if they do, I don't want the interveners to look at us like we sandbagged them and didn't tell them what their burden was.
So,
Okay, yeah, for the.
yeah, I mean, I think, Vice Mayor, are you clear on that?
Oh, yeah.
So I think we can still we can still rule on whether or not an intervener meets standing, but we have to explicitly say that, whereas we
Yeah.
didn't do that this last time.
And the intervener needs to be aware that that burden of proof is on them, and that might be part of the case they have to make
Well,
before
and so,
being allowed to make.
right,
that
and so the case law says that an intervener is, a party is not entitled to participate as an intervener merely because it has a general interest in the issue being decided. Instead, the proposed intervener must show that it will suffer an injury in fact. Standing requires showing that one will suffer special damages that differ in kind rather than degree from others in the community. Merely being an abutting property owner or one entitled to notice of the quasi-judicial proceeding may be a factor, but it generally cannot be the sole factor. One must still show that their affected interest is different from others in the community at large. And that's coming from the case law. So I just want to put it in there to kind of
Mike?
let them know that there's a little more to it. If you guys turn to them and say, okay, give me your evidence.
Mike, could you describe, does this case law or does the statute describe what an injury is?
No.
Okay.
I mean, like, it doesn't say economically, you lose $1, you have an injury. But an example of that would be if I lived south of a flowing stream and I ran a farm and the water was going to be diverted and I wasn't going to get the water for my farm, I could demonstrate that I have a higher injury than just people that didn't want the development.
So if the way this is written, we would rule on it. So if someone, for example, we were having a hearing about a project in Stuart and someone came in from Hope Sound, that just did not, that for whatever reason doesn't like the XYZ Corporation, then we would have the obligation to rule if they were a genuine intervener.
Right.
But even if somebody, to Mr. Mortel's point, even if somebody who was a neighbor filed as an intervener, we would still have to rule.
Right, yeah, I understand that.
If the petitioner called it.
I'm anticipating that the Canner Highway PUD has a second intervener that has applied, and I'm telling you now, there's gonna be an objection to it. This is not gonna apply, this amendment that we're doing doesn't apply to that because it's already in and it's already in front of you guys. So whatever you adopt here or not has absolutely no bearing on that at all. But that's coming.
But to your point, because, I mean, even.
Right, it doesn't matter, that case law is still gonna be the issue.
It'll still be the issue because
Right.
it's the case law.
Right.
So
So
they
it has
can still
nothing to do
file
with
an
our
appeal.
ordinance,
Right.
but that's still gonna happen.
What's the case law? Can you give us?
Miss, wait on, you can have a question when we ask for the public comment, thank you. Was there, did you make a motion in a second?
Yeah, we
We had a
moved.
motion and a second.
All right.
My edits were just,
I don't have any card,
Minor.
but I heard a comment. Would you like to come and make a comment, Miss Hall?
No, I was just
Anything?
wondering what, the case law, what case was that and what court, that's all.
That's a general reference to precedents, is that right, Mr. Rowan?
I mean, I can provide all of the, I don't have it with me on the agenda, but I can provide it.
Thank you. Ms. Helen McBride?
Helen McBride, Flamingo Avenue, thank you. I'm a 48-year resident of the city of Stuart. I was here that night.
Bring that up to you, Ms. McBride.
I was there, I spoke at 10 minutes to 2. If you remember, this lovely gentleman did make sure I got out safely because I had to park out on the sidewalk. My sister Jean was furious. She said, don't you realize you're 85 years old and you shouldn't be out at 2 o'clock in the morning? So it made me feel good, sound like my mother. But anyway, I think really you got to tighten up on the intervener because I've been to many in the county because I vote for the county commissioners like I vote for you 5 commissioners. At that night, I thought you 5 could have done a better job. When the intervener had her witnesses, of course, they didn't have their homework done, but that one witness got up and started throwing stones at our commissioner. And as a city resident, I took offense because it's my vote that put people up on that podium, no matter who or when. I've been here a long time. So I really feel they're better control of the interveners. I mean, just because I got the airport behind me, and that's in Martin County, and I don't like it, so I can pay a fee and have all my friends come. You got to tighten up on the interveners in time. I mean, for the many years I've been here, and I've been at the commissioner meetings, you run a wonderful, but that night, it did get out of hand, it really, and like you said, it should have been much earlier when you know, and like if you say there's another case coming, put it on the agenda a little bit earlier. And I feel sorry for the ones who are after it, but tighten up on that. And there's another little thing that's always bothered me. I vote in the county for the commissioners, I vote here. And that night, like they were coming up from Hope Sound, and they didn't mind Costco. Well, I don't know. I was at the Memorial Day parade, and when you all went by and I waved, and some of you yelled, "Hi, Helen," and that, there was a group of young people with young children, so I let them stand in front of me to get the candy. They all stopped. They said, "Did you go to the meeting?" And I said, "Yeah, I kind of go to all the meetings." And all of those young people, and then my question, do you live in the city? And they're all for Costco. So, you know, it's like tonight, this meeting, you started here at 4:30. These young couples are working. They're probably both working. They have young children. So we, the people of the city, Stuart, and I haven't found too many who are against this development. But I mean, tighten up on the interveners. Thank you.
Thank you, Ms. McBride. I see one more comment coming up. Is that Ms. Linda Kay? Mr. Lloyd?
Thanks again for hearing me. It just seemed to me like there was some synergy between what I had mentioned before and this particular topic. So I just wanted to bring up that, again, I think if the intervener, it was very apparent in this process that took place that city staff worked very closely with the developer in understanding code and working around issues. If that same thing would happen with an intervener where they understood what the rules were up front, I don't think a lot of people would waste their time coming up here to be told they're not experts. When even though we are experiencing what's going on out there and it should count for something, we would certainly have placed the emphasis on making sure that the expert was representing us and counteracting or counterbalancing what you're hearing from these people. Because I totally agree. What you heard from these people is a one-sided thing paid for by the person of that interest. On this side, if we knew that we needed to have that, you would have heard that from the same qualified people that these people brought. And this leads me to say, because none of this is really understood apparently, should we go forward making decisions when we still can bring experts? We could still bring you experts that can give you valuable information based on what is existing and what we see. So you should definitely take that under consideration. Time limits, I think you're right on. You need to give the amount of time that's necessary so you guys understand all the issues and all the details of all the points. Thank you.
Thank you.
Thank you. We have another comment. Thank you. Amy?
I'll answer to both now.
I keep doing.
Very quickly, I read a piece from, I believe it was Mr. Campenny, who talked about how many people spoke that night. 28 spoke against, 12 spoke for, and 30 people were not even able to speak. I'm not a mathematician, but that's 42% of the public that didn't even get to say anything. I think that's an important thing to note. And also, one of the things you may not be aware of is we have over 1,450 signatures online and 200 paper signatures against the project that we haven't even presented. So just a little bit of numbers. I think 42% of your public not being able to speak is relevant. And out of those 42, how many might have spoken against and for? Do not know that. But if you go by how many were here and spoke against and for, it was overwhelmingly against the project. Thank you.
Thank you. Are there any other comments on item number 8? Ms. Linda K. Richards? You've had one bite at the apple. Well, most stores people have had.
So obviously I felt kind of like there was some talking about me as an intervener here with the Costco thing. And so just as a concerned citizen who has been working very hard and has spent a big chunk of my time over the past few years with this, it actually leads me to feel like, well, I guess there goes my chance to be an intervener, because looking in the future, I see myself sitting up here and basically being told, even though my business and my property and where I live are all within spitting distance of this property, that I could be denied the chance of being an intervener. And that being said, I want to speak one other thing about this is that I know there was discussion about allowing public comment before presentations, or allowing public when you're expecting a long process like we did before. And I would like that to still be a consideration for the Cantor CPUD, is that you allow public comment before the presentations of the applicant and the intervener. The staff can present it and then take your public comment, so that we don't have people who are silenced. Because unfortunately, I really disagree. There are people who think Costco would be great, but once they know the location, and once they know the apartments and the strip mall and the fast food restaurants, once they know what it really is, it's not about just the Costco. They go, what? So people who say they want a Costco, they are not informed as to where it is and what the impact is. So I would really like to ask, when you're speaking to people about this project, just to ask them if they know the details. But I know that's not about here, but I do think public comment needs to be heard. And we actually should have requested a continuance at that meeting and said to go to another day so the public could have been heard. Thank you.
Thank you.
And Madam Mayor, as it relates to the case law, just so I could summarize this, will you give me 2 minutes just to read it, so that because I
Yes, Mr. Mortel, if you
So-
could cite the citation
will.
so they can look.
So I pulled this right out of a conference I had attended, and I had sent this to Luke Latham, who was that intervener in the case before. Who has standing to petition for first-tier certiorari review, and when must they prove standing? Standing is an important, often overlooked issue by petitioners. The Supreme Court has long recognized that to challenge a quasi-judicial land use decision, the petitioner must have and prove standing. Renard versus Dade County, 261 Southern 2nd, 832, Florida Supreme Court. Although one could devote an entire article to this topic. The city attorney should primarily keep two issues in mind concerning standing, especially when someone other than the landowner applicant petitions for cert review. First, city attorneys should know the test for standing in the land use context. And for those in the audience, standing is to be an intervener, which is not governed by any particular statute, but instead by Florida common law. The Supreme Court has long recognized that standing requires showing that one will suffer special damages that differ in kind rather than degree from others in the community. It at page 837. Merely being an abutting property owner or one entitled to notice of the quasi-judicial proceeding may be a factor, but it generally cannot be the sole factor. It at 838. One must still show how their affected interest is different from others in the community at large. Each case must be independently researched based on the nature of the challenge. For example, merely alleging that the proposed development will increase traffic is generally insufficient because everyone in the community will suffer the increased traffic. Skaggs, Albertson Properties versus Mitchell's Bel Air Bluffs Pharmacy, 332 Southern 2nd, 113, Florida 2nd, DCA 1976. On the other hand, a liquor business affected by a zoning decision allowing a competitor to open a nearby liquor store would have standing because of the increased competition, which is ABC Liquor versus Skaggs Albertsons at 349, 657, Florida 4th DCA. Also Ryan Corporation versus Board of County Commissioners of Dade County. But see Mitchell's Bel Air at 332 Southern 2nd at 116, which suggesting the loss of business due to increased competition would not support standing. Of course, the desperate argument that if the petitioner lacks standing, no one would have standing to challenge a city's decision has been repeatedly rejected. See Solaris versus City of Miami, 166 Southern 3rd, 887, Florida 3rd DCA, 2015. The second important issue city attorneys should keep in mind is whether the appellate record contains a sufficient showing of standing. Many petitioners forget to present evidence showing their standing during the quasi-judicial hearing and instead attempt to argue standing with no evidentiary support to the circuit court in their certiorari petition. But the case law is clear that standing must be first proven through evidence at a quasi-judicial hearing before the municipal decision makers. See City of Fort Myers versus Split, as well as Battaglia Fruit Company versus City of Maitland. It cannot be argued for the first time on appeal. The circuit court cannot go outside of the appellate record to take additional evidence of standing. Rather, if there's no evidence supporting standing, the petition for certiorari will be dismissed. So that's where it's
Okay.
voted up.
So what I'm hearing there is that if we fail to enforce Florida common law, we could actually, and somebody who is claiming standing as an intervener makes a case on appeal, let's say it was denied, on appeal by the original applicant, because standing wasn't presented.
That whole appeal could be shot.
So it could actually disrupt the chances for the intervener to be able to truly file,
Right.
to file an appeal.
That's
And
exactly what happens.
so it's not just about, let's let people, I hate to say it, but we have public comment, and then to allow people to grease the rules so people can feel like an intervener, but we're sort of like turning a blind eye to case law, actually makes it more difficult for the intervener if they were to actually try to appeal a decision.
And that's exactly my concern. I don't want them to feel like we set them up to get kicked out at the cert level.
So, in my mind, though, this does boil back to, if someone applies to the city of Stuart to be an intervener,
They're coming
they
forward to you.
need to be properly notified that the burden of proof is on them. That even if they're a budding property owner, that might not be enough. That they might have to show that the impact of the new business is going to affect water flow onto their property per se, or something of that nature, or, you know.
And that's
the
why
new
I
business
added
will
that to
directly affect them.
11.03.03B.
Okay.
Okay, any other comments?
Madam Mayor, I'll just say that I accept the vice mayor's recommendation is to edit section, the
I wrote them down.
yellow sheet, yeah.
I think that we were put, okay. And
the other one? Flipping B
green-
and C,
The B and C.
page 6.
Fine. I didn't read it in sequential order, but I'm okay with that. If it makes it clearer to you, then I'm okay with that.
Thank you.
I am
Sure.
too. Okay. And like I said, I brought that up just so that we could have that discussion, to know that it's been discussed whether or not there should be any time limits, and this is what we're working, so this is what we have. Commissioner Bruner, did you have a comment?
No.
Okay.
Ready to vote.
Okay. Did we have any other comments on the, or we have a assistant clerk today. Ms. Pinkston, do you have the motion? And you have the maker of the motion and the second?
Yes.
Okay, what is the motion that you have?
I have,
With regard to making any change?
I have edits to number 11. Does any member of the public wish to make a motion? Edit number 12, add no new evidence is permitted. Edit to number 13, and then edit to number 6 of ordinance B and C is flipped.
Sorry,
And it's
make
page
a
6.
comment, period, not make a motion.
Okay, comment.
And I
sorry.
have I wrote it down as
Okay.
well, so we'll catch it up.
Okay, so you think you have a good idea of, Commissioner Meyer?
And I just wanted to say, I had thought about flipping the public comment to be before the case. The reason I'm not pushing for that is because oftentimes folks will actually hear exactly what's going on by the applicant and by the intervener. And many times I feel like they'll actually want to make a more informed comment later. So even though it pushes it later, I feel like I've seen folks before get frustrated when they're told, no, you've already made a comment, and they have something to say based on the new information. So that's why I'm not in favor of putting comment before.
I agree with that, but
I agree.
All right.
And, Mr. Mortel, would you, in this situation with the quasi judicial, there is a issue that has also been brought to me, whether the chair should completely control all of the conversation with the staff and with the developer, as well as with the intervener, or should you have a system where the city attorney is now calling on these people in a certain manner?
If you look at, if you look
And I
at,
know that I just wanted to bring it out, that's
okay,
all.
but
I wanted-
section 11.03.04B says it says the city attorney shall act as attorney to the board.
Right.
Any motions or objections made by a party may be referred to the city attorney for advisory ruling. The presiding officer shall act on behalf of the board and shall respond to motions and other matters with the assistance of the city attorney. The board shall have the full discretion to direct the city attorney or city manager to rule on objections and procedural issues during the hearing. So I don't think 99.9% of the time that you guys want to delegate any of that. You can process them and handle them and deal with it. If it comes up and you guys feel the desire to do that, at the discretion of the board, you have the authority to, but most of the time, it probably won't be necessary.
Okay, and this is kind of outside of the ordinance that we're discussing right now, but, and I normally don't respond directly to what, when people come up, but I think one of our first questions was with regard to how people know how to approach, and I think the idea of definitely defining the intervener and whether an intervener is coming with a team of people, they need to work on that. But is there something that we can do as we amend this ordinance, and maybe coming out of this ordinance, that we have something like a cheat sheet for them so that they know when they submit their intervening packet that they're going to have to provide certain specific things in there, whether it's to have specs that says that this person is a qualified person to do X, Y, Z, similar to what a developer, when they bring in someone, they know that it has to be a qualified traffic engineer, has to be this, has to be that. Is there anything that we could offer to the public that are coming into these things who are not well versed in it, that they can have a little flyer or brochure that says, if you're an intervener on a land use matter, these are some things to X? And not that we're being their attorney either.
Well, that's what I was gonna say, we have to be careful, because if we forget something and then they don't do it and they get reversed in circuit court because it wasn't on our sheet, it became our fault, and then we've created the problem. We do try to meet with them and answer any questions they have, but unfortunately, unless you've been through it, you don't know what your questions are. You know, the questions don't happen in advance, they happen during or after. And I did provide the interveners in this particular case we keep referring to on Kenner Highway on April 16th, an 8-page memorandum that I had done for the city manager regarding the procedural requirements afforded to a participant in a legislative proceeding such as what we were doing. That talked about the due process and talked about the burden of proof and talked about what a quasi-judicial is, cited case law. The problem with it is when I gave it, I didn't know what the applicant was going to be submitting. And I couldn't really comment on that if I did know, because then that would be representing one side or the other. So it's a fine line to draw. Now, the reason the applicant has the meetings with the city isn't because the city's giving them extra time. It's because the applicant has been paying a lawyer to represent them, an engineer to represent them, an architect to represent them, and a land use, in this particular case, for almost 6 years. So, you know, there's no way we could ever provide that kind of information to somebody. I mean, it just would be impossible.
Okay, I just wanted to make sure we brought it up and discussed it at this time. We have a motion, we have a second, we've had discussion, we've had input from the public. Are we ready? Sir, hold on one second. If you'd like to come up, Mr. Lloyd, I'll allow you because we want to be fair.
I thought maybe you had more input, Mayor, I'm sorry.
Oh, do you want to have, okay.
I just wanted to address what I heard. And so a suggestion would be guidelines, as you, I think, suggested, and a disclaimer. And put a disclaimer in there that the city is not responsible for these guidelines, but we suggest, because you don't want to waste everybody's time. These are the people you represent. You don't want to have them come up here and be disappointed in your leadership because you're not leading them. These people, staff, and I'm not saying this in a derogatory manner, but they worked extensively with your applicant. Wouldn't you be able to give equal time to the people who you're affecting? Put a disclaimer out there and protect yourselves.
Thank you for your input, sir.
And for what it's worth, I did meet with the applicants in advance on multiple occasions, offered to meet with them. I know that staff met with them. I also have a scheduled meeting with them on July 6th to go over it again and meet with them to try and put together the procedures to make sure. And sir, if you give me your email, I'll be happy to provide you with the 8-page document I gave them in advance as well.
And I'd like to say this, that we have 5 commissioners up here. We represent the entire city of Stuart. The places that we sit have a number. It's called a seat number. Well, we represent the entire city of Stuart. And our best times, we actually work, and we work hard at what we do as commissioners and as leaders. The best time is to get us in a meeting. Call us. We will sit with you for an hour, 2 hours, whatever it takes. We will talk to you. But when you come for the 3 minutes, that's not the time, and that's not the only time to get an answer. And I know that's probably belaboring something that everybody knows, but we just want to remind people again, you don't have to wait to come to City Hall at the appointed date and hour to speak to us. We are here, we're available, 288-5312. Call, set an appointment, we'll be available, we'll come to you, or you come to us. We'll go in the field, we'll do whatever, meet somewhere, coffee, the antechambers, we're here available. So that's not the only time we have discourse. So please remember that and use that opportunity and use it wisely. I think the same thing goes for staff, city manager, and the city attorney. Mr. Meyer?
Shall we call the question, Madam Mayor?
Yes, sir, I was about to call that.
On this
when
first
Mr. Lloyd
reading,
came up.
so we'll have another chance to talk more.
Yes, sir, first reading. We'll call the question. We're going to have, the city clerk. Okay, so city clerk has confirmed the motion and the second. Okay, city clerk?
Commissioner Bruner,
Yes.
Commissioner Meyer,
Yes.
Vice Mayor Matheson,
Yes.
Commissioner McDonald,
Yes.
Mayor Clark.
Yes, thank you. We're now at item number 9, which is a variance to reduce upland buffer distance to significant wetland resources. And is that staff, Growth Management Department will discuss that?
Yes, ma'am. This item is a request for a variance. It's before the City Commission tonight because the Board of Adjustment does not have the authority to grant variance for upland buffer distances. So this is a request to a variance to the city's Land Development Code, Section 5.03.02.C.1 and 4, for a reduced minimum upland buffer distance from an outstanding wetland resources, reduced average upland buffer, reduced construction setback from a wetlands for Lot 5, 6 on Southwest Indian Grove Drive in order to accommodate a single-family dwelling. In general, as I stated earlier, these variances are normally granted by the Board of Adjustment. In this respect, they do not have authority to grant a setback to a wetland buffer. So this is why it's being brought forward to Commission tonight. There are limitations to granting variances. So you have to look at variances that will not be in contrary to the public interest, where owing to special conditions, a literal enforcement of the provisions of a certain part of this code will, in an individual case, result in unnecessary hardship, so that the spirit of the code shall be observed, public safety and welfare secured, and substantial justice done. There are a number of findings that Commission would need to go through. Do you want me to list those as we go, or move on?
I'm okay to move on.
Yes.
Thank you.
Yeah.
So we start with the comprehensive plan in this respect, and Commission maybe have a recollection of the appraisal and assessment report that was done recently, and in part of that, there was a discussion regarding wetlands and buffers to wetlands in terms of residential properties that were fronting particular creeks, and whether or not that they could accommodate the 75 feet that were allocated into the comprehensive plan. In terms of that, a discussion was held, and in certain instances, residential properties would be exempt, and that is a typo in that code, from the minimum average buffer of 50 feet and minimum width of 25 feet. Those are the properties in question that were placed in the comprehensive plan, and you can see that they're primarily residential properties. Most of the existing properties that are along those do not meet the 75 feet setback. The property in question tonight is Lot 5-6 Indian Grove Drive. The reason for the variance, even though the comprehensive plan allows a reduction in the buffer, in the Land Development Code, two policies, 5.03.02C1 and 5.03.02C4, is a requirement for a minimum average width of an upland buffer around an existing resource wetland shall be 75 feet and at no point be less than 50 feet. And those are the two issues that we face in the land development regulations, and the reason for the variance tonight. And also the land development regulations incorporate a requirement for a construction setback of 10 feet from the upland buffer. So the request tonight is for a reduction in a upland buffer requirement of 75 feet, a construction setback of reduction to 0 feet, and the property is located adjacent to Popperton Creek. So there's an aerial of the location of the property. It's zoned R3. And now I'm going to go through the restrictions on this property based on the existing code and comprehensive plan requirements. So if we, first of all, allocate the setbacks to an R3 for a single-family dwelling on this, you can see the 5 feet side setbacks. The 15 feet front setback can be set if the dwelling has a porch. Otherwise, it's a 25 feet front setback. The rear setback would normally be, in terms of an R3, a minimum 15 feet. However, we have within the site a wetland boundary, and the location of a 75 feet wetland buffer would, in all respects, totally eliminate any development right upon that property. Even the reduction of 50 feet wetland buffer would only allow a certain small segment of that property to be built upon. And then if we appoint the 10 feet construction setback to the 50 feet wetland buffer, then that area reduces further. If we apply the comprehensive plan requirement or allowance to 25 feet wetland buffer, then the developable area of that lot becomes more reasonable and could accommodate a reasonable sized single-family house. If we apply the 10 feet construction setback, then obviously that is reduced, and maybe a smaller, very small single-family residence could be accommodated in there, but it's still quite restrictive. So the variance request is for a reduction to 25 feet of the wetland buffer, the elimination of a 50 feet average wetland buffer, and the elimination of a 10 feet construction setback. And that's staff's presentation. The commission should review the criteria for reviewing a variance, receive testimony from the applicant, and then receive public comment, and then make a determination. Thank you, Chair.
Thank you. Board members?
Madam Mayor, I do have a quick question for Mr. Freeman. Do you have the square footage breakdown of the yellow area on the slide?
So that yellow area there now is approximately 2,500 square feet.
Can you give me that same breakdown if you remove the 10-foot construction
That would
setback?
reduce it to around 2,000 square feet.
So around 2,000 square feet without encroaching on the 10-foot construction setback?
Correct.
Thank you.
Okay.
That's all my questions.
Yes. Any other comments on the staff's presentation regarding this variance and the impact of the wetland buffer area?
Madam Mayor, I have a kind of a procedural question, I guess. With the last applicant on the neighboring parcel, they had requested, I believe, to change zoning?
No, the R3 does allow duplex.
Right, they were.
There was also a further request to eliminate or reduce the front setback.
Setbacks as well.
Which made it. And this, if I go back to the aerial, you'll see the differential between that location,
Right.
which is adjacent to the left, which is a far longer rectangular site than this is a more compressed site.
Right. I guess I'm just curious as to why with the previous application, we did see some renderings and some proposed site plan, although it wasn't, hard in the way that you would receive it for a permit. If we were to grant this variance, let's just say we were to grant this variance per staff's recommendation this evening, do we then lose any ability to have the property owner come back to us to look at what would be built there?
At this moment, yes, there's no obligation for the property owner to reappear. There could be conditions placed on this variance to, one, restrict it to a single-family house.
Right.
I don't know if the applicant wants to talk about that.
I think well, for me anyway, part of the reason why I was hesitant to approve the variance in the past case was that we were looking for, I was really interested in the actual elevations, the floor plan, the site plan, just to have it be a little bit more graceful on the wetland and buffer. And with this, we don't have that potential information.
The applicant did supply some plans early on, but they would not fit into the reduced area.
Okay. The other concern I have is that, I mean, certainly, we have one issue here, which is we're protecting wetlands and buffers in our code, but we're also, I'm thinking about, the future of sea level rise and flooding, and this particular area is quite endangered into the future, into perhaps the near future. And so I'm wondering the wisdom of us approving a variance for something to be built that could be flooded in the next, regularly within the next 20 to 30 years.
All right, I see that we have we have a member of the public who wants to make a comment.
It's the applicant.
Yes, yes.
Good evening. My name is Karen Johnson. I purchased the property in 2004. Oh, I live in Jensen. I moved here in Martin County in 1972. I purchased this in '04, and at the time there was a 20-foot setback at the time, so it looked very buildable. After all the new setbacks and the buffers, it was unbuildable, but I did not know that until I came to the other gentleman's meeting here. And so I had an architect draw up something that would fit on their property. If we wouldn't get the 10-foot buffer, the east side of the property could only be less than 10 feet wide or long, however you want to look at it. Oh, sorry. May I show this to you? This
thing is it similar to what we're seeing on?
This is an architectural design that.
If you could just maybe hand it to us and then use
We
the
can,
microphone.
we can
so
pass
you're-
it around.
Okay, I'm sorry. Thank you, Ms. Johnson. Sure. So my projection is not to put a huge duplex on like Mr. Douglas, whatever his name was. It was not to do that. It may be approximately the 2,500 square feet to the max. On the left side of the property, you can see that above the garage, I may put a one-bedroom, like an apartment up there, or a residence for my daughter or someone, that could live there, because I know it was zoned R3. So I just want to let you know that I paid over $30,000 in taxes in the last 17 years. I did have the Department of Environmental Protection come and look at the property. It has only risen like less than a half of a foot. So I do have the studies on record. The Army Corps of Engineers, sorry you guys, this is really out of my wheelhouse. They are doing a study as we speak. So that there was one little discrepancy, and it was like right here. And if you would mind showing them, that's the only discrepancy of the size of property that the footprint that I was trying to build on. So that's pretty much it. If not, the lot is unbuildable, and I'm begging and asking for you to.
You're asking for the 10-foot construction buffer
To be waived, yes.
to be waived. Do you need the entire 10 feet?
I do, because if it's not buildable.
Okay.
So.
It's a one-story building you're planning to put
It was
there?
like a 1.5. It was above the garage, because if you look on the property, the west side of the property is about 48 feet buildable. And so that was my only potential to even try to go in for a 3-bedroom or to go in upstairs.
Kind of like you're playing like Tetris.
Believe me, looking at that, my architects had, quite a chore.
I give them credit for creativity.
Well,
So-
and if I can just say, thank you for bringing these renderings, because this is sort of what I was looking for, something to this effect, where you are changing the building footprint to accommodate the wetland barrier.
And I just want to let you know that when they did their dredging out in St. Lucie, LeConte, I don't know like what year, but we allowed LeConte engineers to use my property because it was the only one that didn't have mangroves. So I do and did allow the city to use my property for a barge. And, believe me, when I drove down my street and saw a barge on my property, I wasn't happy. But I did allow them to use my property for a lot of things.
Well, I don't want to hog up all the.
All right, I'm just going to give everybody a chance to look at this.
But you want to see the rest of this is that's the nuts and bolts.
Staff, you've seen these plans?
Yeah, the only comment staff would make is that the footprint doesn't fit into the area that would be, there's a slight clip on one of the pieces.
Yes, right.
Yeah.
This one right here, this shows where everything fits in that.
Yes.
No.
Yes,
Is that a revised one?
Yeah, that's a revised one, but
Okay.
at the very last, the second, ledge or edge of the house on the east side, it has to be tweaked about, I think it says 15 inches. So I have it written on one of those papers that I have to have the architect, diminish or, minimize just that ledge.
Can I ask, Madam Mayor, can I ask a question of
sir.
Kev? Was there any discussion about potentially reducing the front setback in order to move everything a little bit forward to reduce the impact to our buffer?
Well, we did not. We did, discuss the fact that they could come to 15 feet with a porch. We thought that eliminate the amount of variances.
Mhm.
But I think if Commission were more minded to bring it forward, that may work.
I mean, I would defer to sort of your expertise on.
Well, we were looking. One of the considerations when we look at a street is how that street forms,
view shed.
the rhythm, and the front setbacks along the housing down there. And if I go, it's fairly regular down the street.
Excuse me, but when they put the new
Yeah.
FPL the new FPL lines in, it diminished my property
Yeah.
again. So if
So,
you look on the east
yeah.
side of that property, the lines have kind of angled, right? I mean, for better wording, I don't know, but it's angled, so it had taken more of my property.
I generally would
There's
be, I would prefer to, without disrupting the view shed and the safety of, driving down the street and having a building, right up against the sidewalk, I'd prefer for us to move it forward, if possible, to reduce the impact to the wetland and setback, just as a general principle. I know we talked about that the last hearing. And we did pass, this would have to be, based on the new codes, this couldn't be fill, right? This would have to be stem wall or.
Yeah.
What about, even if we just moved it forward a foot or two, just to get us a little bit further away from the, I don't know if that would work.
Well, we do, and the applicants mentioned, yeah.
Because I'm worried about being so close to the road.
There is, the applicant mentioned it, there's an FP&L overhead line there, and I think it does encroach on the eastern side of that property where it jogs back.
When I bought the property, the FPL lines were not like that. There were so many changes. So that's what's happened. You can see the electric pole right to the right of it, standing straight up. And then the next pole is over on Mr. Douglas, or Douglas' side, and it kind of cuts my corner off. And you have to stay the 15 feet from the FPL lines. So I've been restricted pretty tough.
What, you're really boxed in.
I
Was
am.
the FP&L easement there when you bought the property?
No, it was not. I have the original,
So since
Property.
2004, they got a new easement on your property?
recently, probably in the last 5 to 6 years, the FPL lines came in differently than they were on before. So I do have all the original paperwork that I had when I bought it in 2004.
What's the square footage of the plan
It's
currently?
Right now, it's about 1,800 square feet on the bottom floor, and like a one-bedroom efficiency about 600, less than 600 up, so not more than about 2,500. I was not exceeding any more than 2,500 square feet.
Okay, nothing else, is there a?
Yeah, I am a little concerned about the idea, because we heard the same thing with Mr. Bornick, about the setbacks used to be 20 and they've changed. And I worry that when somebody sold this property to these folks, that they were told something that wasn't true, because our comp plan, I mean, we didn't recently change and increase our setbacks, to my knowledge. That the last thing that we went through after the EAR was to provide for relief in these.
I think there was a period of time in the city where inaccurate advice was provided.
Right.
Because there's when these properties were,
In that 2004.
yeah,
Because that was the same timeline as Mr. Bornick, and he said the same
That
thing.
letter that was sent, I remember that in Mr. Bornick's
Yeah, I have the
case.
approval plans that
Yeah.
were approved by someone, I don't know who. Like I said, this is out of my wheelhouse, but these are the original plans.
So
Mr. Mortill, do you have any input?
I would get a title search before I bought property.
I was the one that pushed for the increased wetland buffer in our comp plan, and I, said at the last hearing regarding the neighboring property, the intent was not to make the lots unbuildable, and I support the changes we've made. In my mind, I can support going back to the 25 and keeping the 10-foot construction buffer.
Keeping the 10-foot construction buffer?
In my mind, I feel like that's still a buildable lot. Right now, the proposal before us is, a 2,400 square foot house is, I guess I'd be curious to know what the buildable square footage is, keeping the buffer.
10 foot.
The buildable square footage seems significant with keeping the 10-foot construction buffer. I guess I don't want to set a precedence that we change one thing for Mr. Bornick, where the intent was not to remove the buildable quality of the lot, but when Mr. Bornick came before us and stated for finances he wanted a duplex with rental incomes, I'll support that in some areas of the city, but, these properties, all in yellow, the intent of the change was to try and preserve, high-quality wetlands that are right next to a river as much as possible. And I have a hard time seeing that you couldn't reduce the square footage of the house and
But the
not
square
fit
footage
it in
is
the
true, like on the
buffer.
one floor would be about not even 1,800. It would be between 600, because I'm going up only on above the garage. That's the only reason why it would be a 2,500 square foot. It's because I'm going up, not the footprint. Does that make sense?
Yes, but there's nothing preventing you from going up in the smaller
The
property.
power lines are going to dictate that, because I can't do it on the right, I wouldn't be able to do it on the right side and stay within their 15 feet and staying compliant with the FPL lines.
What is, I was looking for the plans again, on the right side, the narrow side?
Yes.
Can I see, yeah, I want to see.
It would be less than 10 feet
Yeah,
on the
that's what I
right
wanna
side.
see. I wanna
There
see
would
what
not
the-
be any, length.
If we were to preserve the 10-foot.
Yes.
In addition to the 25-foot.
Yeah, so
Miss-
this house it would be 15, it would be like 15 feet. And then, let's see, yeah, so it would be like 15 feet. And then here, that'd only be a 15-foot deep house. I mean,
By
On the
time-
side.
actually, not only on the side, but even if we move everything forward 10 feet, everything gets reduced, because even in the center, because of the porch, if you look at the, you look at here, this is 25, roughly 25 feet from here to here, or it's a little bit bigger than that from here. It looks like it's 29 feet right here. So if you take this section of the house would be just cut down to almost nothing.
Mr. Mortel, do we have any legal liability for setting precedent one lot down?
Well, you never set precedent. Every single time you guys do it, you follow the code and you follow the law. If within the next 29 days, someone were to challenge it and you were wrong, then it could be reversed based upon a challenge. If it doesn't get challenged on day 31, it becomes binding on this property. But it doesn't, you're not passing a new ordinance.
Yeah, this is a
It's just
variance.
this approval becomes binding on this property.
Each property at a time.
And mind you, if you look at the property, there was a building next to Mr. Bornage, or whatever,
Bornage.
on the west side of his, that we're trying to follow their guidelines, as we're trying to put the porch in its right place, give it everything, I tried to comply with everything, and to make it buildable. And at this point, it would not be buildable.
How long have you said you've owned it, since 2004?
I've owned it since 2004.
Madam Mayor, I'll just say, I agree with you, Vice Mayor. I mean, I'm hesitant to eat into the 10-foot setback in addition to reducing the minimum setback on a critical piece of wetland. But I also understand in this case, the extreme limitations here. As much as I would love to see, a tiny home plopped right down that's 8 feet deep that I could move into, I probably still couldn't afford it. I think we have to be realistic about the intent of what we can do through variance. I'm willing to entertain the 25-foot and waiving the 10, but I want ironclad assurances in there that, however we can to know that this isn't, and not to say that you would at all, but that this isn't just going to get flipped and whoever wants to do whatever is just going to do whatever the next day,
I agree.
That we can have some assurances that what we're seeing here is generally what
It's gonna happen.
was going to happen.
We can do this.
Well, unlike I was here for Mr. Bornay's meeting, and he needed it to survive for, on his Social Security or whatever he needed for. I don't need that. This is not going to change my life in any iota. I don't know what I want to do with it. I have to first get it buildable. So, and I thought it was buildable, or I wouldn't have spent $30,000 in taxes.
Right, and that's where I understand, there's already all these taxes paid under an assumption that, it was more buildable than it is, even though the code hasn't changed. One last thing that I'm curious about, the parcel to the east,
Yes.
that is conservation, right? It was public?
City-owned.
City-owned.
City-owned, yeah.
Oh, that's right.
Yes, there's a little, and believe me, I've come over there for nomads, being back there, and I've tried to keep that place, and you can see, mine's the only one that has been manicured every month. There is a small, I will not touch any of the mangroves. I have about an 8 to a 10-foot path that there are no mangroves. That's why I chose that lot. I saw the others, at the time. I didn't want that. I don't want to cut up, mangroves. So mine has an open spot. I'm not going to endanger anything.
I believe she's going to do the right thing, so I'll make a motion for approval.
Thank you.
With what you want to add, we'll talk.
There's a motion by Commissioner Bruner.
I'll second the motion for discussion and.
Yeah, I just wanna
let's
hear-
start- Let's look at some of the, make sure we have all the issues covered.
Yeah, Kev, I mean, you guide me, please. You had mentioned, the reason I'm chewing on this is because you had mentioned that we could make it a condition. So can you just walk me through what our possible condition could be?
I think we could base it on the fact that the property should be developed for a single family only. I don't know if we could reference that plan to be adjusted to fit within the variance as granted.
I don't know what's allowed to be, I mean, a variance versus, like an ordinance of which I'm used to on a, for a
Well,
PUD.
there are conditions in the variance itself.
Okay,
So we can attach that. We can reference the plan with the condition that the footprint is accommodated within that particular limits of the variance.
and the single-family home doesn't preclude her from putting the, what would we call it, the accessory dwelling unit above the garage?
That would be, yeah, that would be allowed within the zoning.
Okay.
What we are saying in that condition is it would not be used for a duplex or multifamily. You're having a single family with an accessory unit.
If we can make it so that generally what we're seeing there in these proposed renderings is what we will likely see built there, I could be willing to support it. I just am afraid of us cutting off, changing basically the buildability of it and then just letting whatever happen there. So if the applicant is willing to have those conditions, then I'd
I will
ask them.
comply, anything just to make it buildable.
I'd ask the motion maker to include those conditions as part of the
Thank you.
motion. And then I could support it.
Ms. Bruner?
I hope that you get to move into your home.
Thank you.
Ms. Bruner, did you hear?
I
Yes,
accept them as
yes,
well as the
and
seconder.
Have you considered solar panels?
I just was trying to make it buildable.
It's not an ordinance.
I mean, it's been a struggle, and I didn't know it was this much work.
Sorry.
So, I was, this is not my wheelhouse.
I
So,
thank you for your information.
Thank you so much.
There's a motion and a second. Are there any members of the public who have any comments on this motion? Hearing none. Any other commissioners have any comments?
I just want to ask the vice mayor if, I see you're
Just-
knitting your eyebrows. Are there things in that, I just don't want to steamroll this. Are you,
I'm torn like a lot of decisions.
well, we all are. Well, I am.
That's all I'm thinking about. I'm thinking along your lines of assurances. I like the fact that it'll be a single-family home and dictated, there's not much, I don't think that we have the authority to do.
Right.
My intent was not to make all the lots unbuildable.
Okay.
All right, we're ready.
Okay. Clerk?
Vice Mayor Matheson,
Yes.
Commissioner McDonald,
Yes.
Commissioner Meyer,
Yes.
Commissioner Bruner,
Yes.
Mayor Clark.
Yes.
Madam Mayor,
Yes, sir?
Mr. Freeman would like to introduce someone.
Yeah, I'd like to introduce you to Erin Wolitka. She joined us about 2 weeks ago now. And she's done about 4 weeks' work in 2 weeks. She got straight into it and really good. So we're happy, very happy to have her in the development department. She's a senior planner in the development department.
Glad to have you.
Welcome to the crew.
Thank you.
Up in the fire. Thank you. Any other things from the board? Pleasure of the board, should we adjourn this meeting?
Move for adjourn.
Meeting adjourned.
Thank you.
Thank you.
Thank